Some say the trouble's in the Pentagon. Some say the trouble's in the street. Some say the president's a paragon. Where's the trouble at the bottom? Some say the trouble's the anatomy. Some say...
Welcome to Human Rights Here Now. Today's topic is the human right to counsel, public defenders, and I'm your host, Keith Gudger. Joining me today are two members of our local public defender's office, Heather Rogers and Mark Briscoe. Heather has been in the office in Santa Cruz for over 3 years. She has served as a public defender for over a decade, including in the Federal Public Defender's Office in California. In this time, she's been helping the less fortunate with legal issues, including those at Guantanamo Bay. Mark has been in our public defender office here in Santa Cruz for over 8 years. Prior to that, he worked in the San Francisco Public Defender's Office for 3 years. He also served as a director of a nonprofit working with paroled and adjudicated youth in Alameda County. Now, according to the Universal Declaration of Human Rights, Article 7, all are equal before the law and are entitled without any discrimination to equal protection of the law. Article 11 says, everyone charged with a penal offense has the right to be presumed innocent until proven guilty. According to law in a public trial in which he has all the guarantees necessary for his defense. To ensure this right, the U.S. has ensured that the indigent will be represented at no cost. Now, we've all heard the Miranda rights in film and on television. You have the right to consult an attorney before speaking to the police and have an attorney present during questioning now or in the future. If you cannot afford an attorney, one will be appointed for you before any questioning if you wish. Now, this goes back quite a ways, but in 1963, the Supreme Court specifically ruled that any person who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. Now, this was the beginning of public defense in the United States. Now, Mark and Heather, you both mentioned to me that there actually goes back much further than 1963. So could you please tell me a little bit about that?
Sure. So the first cases in the United States which guaranteed the right to public defenders were state cases. Indiana in 1858 felt that it was principles of a civilized society to guarantee somebody the right to defense. There were a series of cases that came over the next 50 years, 60 years, leading up to Gideon, I guess 80 years leading up to Gideon, which guaranteed partial rights, but never guaranteed it fully up until 1963.
Wow. And Heather, you mentioned that the Sixth Amendment also guarantees that right.
Right. I mean, for me, I think it's important for people to understand that this is one of the fundamental rights that the founders of our country deemed important enough to put in the Constitution. I mean, there are very few things in the Constitution spelled out as clearly as the right to have assistance of counsel. It did take the Supreme Court to step in and to say that that right demands that the state and the governments pay for counsel for poor people who are accused of crimes. But the Founding Fathers knew that that was something that we had to have to be in a democracy of free people.
Wow, okay. So you both work in our local office. Can you tell me a little bit about how it works? How does someone get a public defender attorney, and what's the process, and what do they expect?
Everybody appears in court at a first date, and it's called an arraignment. When you have an arraignment, basically you're notified of what the charges are against you, and you're asked by a judge, would you like to have an appointed counsel, or would you like to hire your own counsel? In Santa Cruz County, I think the number is about 85% that end up with appointed counsel. And traditionally what happens is someone is required to fill out a financial declaration, and the public defender's office in Santa Cruz is appointed. We ended up handling all those cases.
Huh. 85%, that's quite a large number.
That's about the national average. Okay. Some states are a little bit higher. It depends upon, the demographics of where you live. Big cities tend to be higher. Suburbia tends to be lower. It's not too shocking.
Okay. So what happens then after the arraignment when someone's assigned a public defender?
Well, after the arraignment, the case is assigned to one of us.
Okay.
So we have attorneys in each courtroom who take the arraignments. meet with clients, find out a little bit more about their situations, argue for bail, and then the cases come back to the office where they get assigned out to attorneys for handling. And so ideally in our office, we try to meet with our clients within 48 hours. We immediately start investigating, we immediately start preparing the cases, and we try to defend each and every client as vigorously as we can. So it's a process that pretty much, every week we'll get new cases, we get new clients, we either visit them at jail or we schedule office visits to talk to them, and right away we try to hit the ground running with investigation and working closely to figure out how we can best help them.
Great. So tell me a little bit about that process of going from being assigned, getting the work done. How long does that take? What happens in general, what happens for the person who's been charged?
It's really a case by case. I can't answer that in a global way. It's case by case, and really there are a number of different levels to it. One of them is acclimating yourself to the case. What are the facts? What does the evidence show at this point? Another piece is, as Heather just mentioned, is initiating investigation. Our office has dedicated investigative staff, and we need to figure out what the key issues are in the case and start looking into them. People's memory fades quickly. Getting on that stuff quickly is imperative to effective defense of somebody. And there's a third piece to that too, which is managing both understanding of the criminal justice system and expectations with our clients. Some of our clients have a history in the criminal justice system, some don't. So again, case by case, a lot of what we're doing is educating people about what the next steps are, what the process is, how long it's going to take. Quite a few of our cases take a very long time. Both Heather and I work in a felony rotation. We handle the most serious cases in our county. Some of those cases don't go to trial for 2 or even 3 years after the date of arraignment. Some of them wrap up relatively quickly.
Okay. So I was talking to you earlier, and you mentioned that it's not just your firm that handles public defender cases, and this is, you work for a private firm that contracts with the county. Could you explain how that works, please?
Sure. So our firm, back in the 70s when Gideon versus Wainwright was decided and people around the country were trying to figure out how to provide defense counsel to indigent clients, as the Supreme Court now mandated, our firm stepped in to take the public defender contract. And so Bigham, Christensen, and Minsloff has had the public defender contract since 1975 and has been primarily responsible for providing counsel to indigent clients like the ones that we serve. So my understanding of it, and I hope I get this right, is that there's a pool of money that the county provides our firm every year to be the first line of defense for indigent clients in our county. We do sometimes have conflicts. For example, if there are 2 defendants who are charged in a case, we will take one and then the other goes to one of the other law firms that handles public defense in our community. So we have 2 alternate defender firms, and if there are conflicts beyond that, we also have a panel of qualified attorneys who can take indigent clients. But between all of us, between the 2 alternate defender firms, our law firm, and the panel, every person in Santa Cruz who can't afford a lawyer gets one.
Should probably explain that a little bit as well. There are basically 3 models in California. Most people think of public defenders' offices as being public agencies. Neither Heather or I is currently a public employee. We are not county employees. We are employed by a private law firm. There are 3 models in the state of California. The traditional model most people think about is a county agency. The district attorney's office is a county agency. The public defender's office, it goes county by county. Big counties historically have had public defender's offices, which are county agencies. That's the model that most people think of, but it's pretty much limited to the largest counties in the state of California. There's kind of a mid-level model, which is what we're a part of. That model involves contracting with a private firm to provide those services. That's what we do. And then there are smaller counties that tend to do what they call pools. Individual defense attorneys sign up to be part of a panel or a pool, and they're assigned cases based upon a variety of different methods. Some counties assign days of the week that you show up and you pick up those cases. Other counties have an ombudsman who serves a role filtering out those cases to those individuals. But those are the 3 primary models in the state of California.
Great. So About how many cases a year does your office and you individually have to handle?
The last numbers I saw are a couple of years old. We handle about 5,000 cases as an office, and there are a variety of different cases. People think of felonies and misdemeanors. There's several other types of cases that we handle, all involved technically under the criminal justice umbrella.
Right.
The primary ones are felonies and misdemeanors. And individually as attorneys, you'd have to ask Heather what her current caseload is. Mine's right around 50.
Oh, great. And
That sounds about right. It varies, I would say, between 30 and 50 active felonies at any given time for us. Misdemeanors have a higher caseload. We also represent persons accused of juvenile delinquency, so we have a juvenile team as well.
wow.
I think that's about right. You know, it really varies.
Because you had mentioned that it's higher in some counties, and I remember seeing a number that it maybe is up to 1,000 felonies in Fresno County. I don't know if that's true or hyperbole, but
My guess is that's a little high.
Yeah.
You know, the bigger counties have more. So the numbers that I had in San Francisco, the standard number for a misdemeanor attorney in San Francisco was around 250, and for felonies was around 100. That's a large caseload.
It is.
Santa Cruz, the numbers are smaller, between 100 and 120 for a misdemeanor caseload, and as Heather said, between 30 and 50 for a felony caseload. There are other counties where people are carrying 300 and 400 felony cases, though, and that's a serious issue.
And I should say that's not a year, that's at any given time. So if we went to our
Right.
filing cabinets right now, that's what we would see. So those numbers in the thousands might be per year.
right.
And I don't know off the top what we handle per year,
that's a
to be
good
honest
point.
with you, but
Fewer than that.
Fewer than that.
fewer than that. There's no question, fewer than that. And you have to handle fewer than that, in my view, to be effective.
Yes.
We've both worked in a lot of different offices, and there is a very real correlation between your caseload and how much you can do for each individual client. There's only so many hours in a day, and most of us work much more than a normal work week. Most of us work every day and every weekend to provide good representation. There's only so many hours in a day. With 1,000 cases a year, I think it would be very hard to do our job well.
Yeah. So, is there? I mean, you can take a case to trial, or you can make a plea bargain. How does that work? Is there pressure to get people to plead out? How does that work for you individually?
Mark never pleads anybody out.
Wow.
It's not totally true. I plead people out. Although, to be fair, I have a jury out right now. So if I jump out of this chair and run out of the room, that's why.
Okay.
Yes, there's huge pressure to plead people out, and I'll need to explain why. So there are crimes that are charged, which could be charged at a variety of different levels. You know, the case that I just tried, that I wrapped up 3 hours ago, is a good example of that. In that case, it's essentially a case where someone steals beer from a store in Watsonville. And that case could be charged as a petty theft. It could be charged as what's called a commercial burglary, entering a business in order to commit a theft. And it could be charged as a robbery. Robbery in California is a strike, which means under the new sentencing guidelines in California, you don't do the time locally. You go to the California Department of Corrections, 1. 2, it adds a strike to your record, which greatly enhances any future punishment. So what often happens, this is the direct answer to your question, what often happens is the district attorney's office, and it's not limited to this county, it's not limited to the state, it's limited basically by nothing. District attorney's offices regularly will charge what they think the most serious possible crime they can make a good faith argument about, and use that as leverage to plead people down. So we get cases that are consistently charged as strikes, and the reality is the facts tend to be considerably more mitigated than what would really constitute a strike. So the situation that we often find ourselves in is whether or not to talk plea bargain on a case where the ramifications of a guilty verdict from a jury would be so high. And it's an interesting thing, in California, juries aren't involved in the punishment aspect. So juries don't know about that. You know, a robbery and a petty theft, the only thing they know about that is there's a one-line difference in the jury instruction in terms of what the prosecutor needs to prove. They have no idea what the implications are of a robbery. We do. We work with our clients to explain that, and we're often in situations where we think we have a pretty good case, but an individual will plead guilty to that, to a lesser charge, to avoid the potential ramifications. That happens far, far too regularly.
I agree, and I think another thing that people need to understand is that a person who is incarcerated, who hasn't been able to get out on bail or out on what we call their own recognizance, which means they agree to behave in a certain way to be out of custody while they're awaiting trial, a person who is sitting in custody will agree to almost anything to get out. And so one of the pressures that I see my clients facing on a daily basis is, I'm telling them we have a good case, our investigation's coming back our way, this is defensible, you don't want this criminal conviction on your record, it's overcharged, we can do better than this. And their answer is, if I'm being offered time served, I'll plead to anything. I really don't care what I plead to. So one of the pressures that we face in our criminal justice system, I think, is making sure that we get as many people back out onto the streets pre-trial as possible. And to me, that is a basic human right, the right to fight your case, not from a jail cell where you're already being penalized despite the presumption of innocence, but on the streets, wearing your own clothes with your own dignity, with the counsel of your friends and your family and your community. And I find that when you have a client in that situation, it's much easier to do the work that we want to do, which is make sure that we get the right result, not just the result that releases you that day.
Got it.
I think if you asked anybody in our profession, private defense attorneys as well, you're in a much stronger position with a client who is not in custody. There are no time pressures on you. One thing that people don't realize is you have a right to have what's called a speedy trial, which is you have a right to a preliminary hearing, which we can talk about, within 10 days if you're in custody, and then a right to a trial within 60 days after that, after you are arraigned on the secondary, what's called an information. And with time pressures like that, we can't do our jobs. And the only reason people ever pull their time waiver, force the hand within that 60-day period is because they're in custody. I don't have people out of custody forcing my hand to try a case in 60 days. A case that the district attorney may have had for a year prior to filing charges, where they've had a year to take a look at all the evidence, a year to marshal their forces, a year to gather their information. And then we're put in the position where one of our 50 cases has to get put together, prepared, witnesses subpoenaed, witnesses interviewed, evidence gathered, ready to go within 60 days. I agree completely with Heather that probably one of the biggest problems we face is this issue of having our clients incarcerated. And I spoke earlier about managing expectations. Heather's entirely right. I mean, expectation, wait a minute, I can get out of here? All I got to do is play. I know I didn't do it, but I can get out of here? Great, I'll take it. And friends of ours ask us regularly, why do your clients plead guilty if they didn't do it? Trying to make the argument to my friends, look, a lot of my clients really are innocent of what they're charged with. Why do they plead guilty? They want to go home and see their kids. That's why.
And I think to put a human face on it, we talk about clients in court. We hear the prosecutors talk about defendants. This word, they never say, Ms. Brownell or Mr. Smith. It's always the defendant. But for us, each and every time we say client, we're talking about a real human being who we've sat across from, who has a family, who has children, perhaps mental illness, substance abuse issues, or maybe a glowing past with an amazing history that's going to be gutted by a criminal conviction. These are real people. And so somebody who's sitting in custody, their entire life has been put on pause. Their children may be taken from them and taken to CPS or put into foster homes. They're losing their jobs. They're losing their housing. They're not getting the psych meds or the diabetes medications that they need. Their life is unraveling. And so every day you have someone in custody, you're moving one step further toward injustice, in my view. And unfortunately, in a culture where we talk about defendants, not by name, not looking them in the eye, not understanding who they are and what they've brought to this position, in that culture, it's very easy to deny an own recognizance motion, to set bail too high for somebody who clearly can't post it, and to get that speedy trial done and move on. Close a file and let the cards fall where they may. It's a real problem.
There's a badge of honor among judges about clearing calendars. So the judges are assigned cases on a relatively balanced basis. And there are judges that pride themselves, I can clear my calendar quick. Right? I'll offer them something, a really good deal to get them out of here quickly, get these cases off my caseload. It's not the biggest issue in Santa Cruz. Quite frankly, the bench is relatively fair here. It's a big issue in other counties.
Wow.
I mean, we talk about, it came to light really in the housing crisis, this idea of a rocket docket. People talked about that, and the idea was to get these foreclosures through quickly. It happens in criminal courts too. Happens in criminal courts where people are treated as commodities and they're forced through the system in order to improve numbers.
Well, we talked a little bit about the Supreme Court ruling, making it so that people who couldn't afford attorney could be represented to sort of level the playing field. But what I'm hearing here is that maybe we need some kind of reform in the bail process so that we can level the playing field. If a wealthy person is picked up, their bail is made instantly. But if I'm poor, I'm going to be assigned an attorney in your office, and I'm not going to be able to make bail, and I want to get out as soon as possible. Is that basically what's happening?
Exactly. And bail is not on a sliding scale. So
Right.
what we have in Santa Cruz is a bail schedule. They look at the crimes that you're accused of, not crimes that you're convicted of, crimes that you are presumed innocent of. They look at those crimes, and for every crime, every enhancement, every allegation, they throw on some more money that you have to pay to get out. And so, as you say, a wealthy person accused of a crime can get a bail bondsman. They're out in hours. The majority of our clients are only let out if we can get them out on what we call your own recognizance, which means you're making an agreement with the court to follow a certain set of conditions to be released. This puts judges in a very difficult situation because they're in a situation where they have part of the public clamoring for them to be tough on crime, part of the public clamoring for them, to take back Santa Cruz, to keep our streets free of homeless people, free of people who are on drugs, free of quote-unquote criminals. And here they are faced with a decision whether to let someone out or let them sit in jail. The risk-adverse decision is to let that person sit in jail. The human decision, the decision that promotes justice and promotes the Sixth Amendment as it was meant to be promoted, is to release that person into the community so that they can make a real decision based on facts and investigation and not pressure. It's a problem. I believe there should be sliding bail scales, but more importantly, that if there is not a very compelling reason that you're a danger to this community, that you should be released. We have electronic monitoring systems, we have pretrial services, we have a lot of different ways to make sure that people are doing well in their communities when they're released. And I think the vast majority of time, my clients who are released have no problems released. They're grateful to be home, and they're watching their behavior very closely to make sure that they're not remanded back into custody. So it's a real problem.
It's interesting. One of the reasons that the Bill of Rights was added to the Constitution was abuses that were considered to have happened in England. One of the abuses that happened in England historically was known as debtor's prison. So we created a system where people who owed money were incarcerated, and they essentially paid off whoever they were in debt to by serving time in jail. We've essentially recreated that system. The jail is not full of people with money. People with money get out of jail. The jail is full of people. When I talk about jail, I'm talking about our local county jail. Once someone is sentenced, that's a different thing. But our local county jail, I would say 98% of the people in there are indigent. They're people who cannot afford to bail themselves out. If they can afford to bail themselves out, there is no reason they are in there.
And I think that leads to another issue that we talked a little bit about, which is mental health, which in my view includes addiction and substance abuse issues, and how our local jail in particular has become basically a behavioral health unit for a lot of our community. So if you add not just being poor to the situation you're faced when you're arguing to get out, but also suffering from a mental illness, on top of that, poverty, you're put into a situation where a judge is afraid to let you out. You certainly don't have the resources to get out. And so you end up in custody, waiting for your trial, waiting for something to happen in your case. In the meantime, you're taken away from your medications, you're taken away from your community, all of the structures that keep you on track. And I would say across the board, my clients' mental health issues are exacerbated by incarceration, by jail, to a point where we almost have to reset and start completely over once they are released and try to get them back into their systems with their doctors and their medications. So it's compounded. I think right now if you went into our jail and went from cell to cell, you would see very clearly the human rights issue at the core of our criminal justice system. It's there person by person, face by face, case by case, in these people who are there because they are poor, mentally ill, addicts, or disenfranchised in some other way.
I don't think that that's just an issue in Santa Cruz, although it is, and it's a bigger issue here. I think it's an issue everywhere. And you can trace it back to 1984. I mean, it's the legacy of Ronald Reagan. 1984, Ronald Reagan defunded the National Institute of Mental Health. And when that happened, the homeless population in America went from 500,000 in 1984 to 3 million in 1985.
Wow.
And where did those people end up? I grew up in Pennsylvania near a huge state hospital. I think there were 10,000 beds at it. It was called Byberry. And overnight, that place was emptied. It's a ghost town now. You drive by it on US 1 on the East Coast. And where did those people end up? They ended up on as clients of ours, you know, on our calendars. They ended up in the court system. What many people don't realize is there's a separate medical funding stream for people in custody than there is for people who are out of custody. So the day you go, and let's say you have Medi-Cal or Medicare, the day you go into custody, you lose it. It's gone. The jail can no longer bill the state or federal for funds, the federal government for funds, for mental health services, for any other services. They're stuck with whatever the funding level is allocated by the state, and it's woefully inadequate. The fact of the matter is the county is not funded, and it's not any individual in the county's fault. It's the big decision making that's occurred out of Sacramento. When I started here 8 years ago, there were two dual diagnosis programs in the county. That's places you can send somebody from jail as an alternative to incarceration who suffer from a dual diagnosis. That is, a discernible mental health issue and addiction. Now, the DSM, the Diagnostic and Statistical Manual of Mental Disorders, will tell you that addiction is a mental disorder.
Right.
But those are two different things. It's an Axis 1 and an Axis 2 diagnosis. We had two facilities like that. When funding got cut for the court system and Santa Cruz had to retract its programming, for instance, shutting down most of the activities in the brand new Watsonville courthouse, reconsolidating everything back into Santa Cruz, those programs shut down because there was no county funding for it. So for at least 3 years, there were no dual diagnosis beds to put people in Santa Cruz County, 0. So the funding has come back and they've reopened one of them. But I think there are 8 or 10 beds there, and we have way more clients that are in need of those services than there are facilities to handle them.
I have 10 clients right now who need those beds, and I'm sure that Mark does. So, and we're just 2 public defenders among many facing these issues.
We'll thumb wrestle for who gets to go later.
I'm going to win.
Probably.
Well, it's not really a laughing matter. It's really sad. So why is it that Medicare and Medicaid stops when you become incarcerated?
You'd have to talk to someone who's got a better understanding of the politics of state and federal billing, but it's the way it works. When you go into custody, your mental health and physical health services are allocated through a different funding stream. And it's the money that goes to the jails to house those people. That's where the money comes from.
Well, your medical conditions don't change.
Medical conditions don't change. It's funny, earlier we had a conversation before we started this about kind of the need for services in custody. And the reality is nothing changes. We also talked about how people get elected. These are political decisions that are made, right? Political decisions. Where can we cut funding in Sacramento that won't start a riot in Marin? Where can we cut funding that won't start a riot in Sacramento? We'll cut funding for health services in the jails. No one's going to care. We've already cut off the right to vote for those people, so it doesn't matter. Inmates can't vote anymore. Once you have a felony conviction on your record, you lose the right to vote. You can't vote. Those people aren't going to get us out of office. You know, for 40 years, people have been getting elected in America on a tough on crime. Get tough on crime. It's the only way to get elected. You can't say, we need to get soft on crime. When was the last time you heard someone get elected on that? You can't do it. The decisions are made politically. They're made politically in Sacramento, and Santa Cruz pays the price. Our clients pay the price. Talk about human rights abuses. It's one of the most egregious we deal with.
There have been some recent propositions, though, haven't there, that have lessened some of the sentencing guidelines? Or can you talk about that?
Sure. I mean, recently there's been a big push towards sentencing reform, and I think it's helping. It hasn't fixed these problems, but I think it's helping, and I think it's helping to bring to light some of the issues that we're talking about. So there are a couple of things going on. There's AB 109, which basically changed where certain convicted offenders do their time, and it switches it from prison to county jail. We call those county prison sentences. It also came with some money for rehabilitative efforts, and I think that my clients who have had AB 109 sentences are doing a lot better when they re-enter the community than had they been sent to traditional prisons. So this is a good thing, and it's something that's helped. We also have recently Prop 47, which turned certain nonviolent felonies into misdemeanors and allows people to have less of a stigma on their record. So for something like theft, in the past we had relatively petty thefts that could have been felonies, or other nonviolent cases such as possession of methamphetamine that could have been a felony. That stigmatizes you, takes away your right to vote, subjects you to prison where there are very few rehabilitative efforts. And now that we have a system that sees those as misdemeanors, our clients have more opportunities. But unfortunately, this is just the tip of a very, very big iceberg. And so while these are amazing reforms and great reforms, and some of the best that I've seen in my career as a public defender, this just has to be the start of a bigger movement toward true criminal justice.
I think the tide's turning. Yeah, there have been, if you go back through the last 100 years, 120 years now of American jurisprudence, there are a series of cycles of get tough on crime, realize that that doesn't work, getting more lenient, trying to find alternative programs. And they're historically 30-year cycles. Quite frankly, this one's been a little longer. It's been 40 years. I personally attribute it to McGruff the crime dog, but that's my personal opinion on that. They did a really good job marketing that guy. But we're now at the point where, you know, the pendulum's starting to swing back the other way. You can't keep doing what we've been doing. It doesn't work. It's the definition of insanity. You can't keep locking people up for a really long time and assuming things are going to change. California's recidivism rate was at 73%.
Wow.
That's what happens when you don't treat the underlying problems. That's what happens when mental illness goes unchecked. That's what happens when people who go to jail don't get services. That's what happens when you give up on any type of rehabilitation at the state level, which has happened pretty much. Prisons are housing facilities. They are not trying to rehabilitate anybody.
Right.
There are no services there. The only services are being offered by nonprofit agencies coming into them and giving services. The state's not providing them. Counties are a little bit now through some of the funding that's come down through AB 109. We're starting to see some of that. We're starting to see more nonprofits get funding through the county, coming in here and starting to make a difference in the lives of our clients. And it's been nice to see. As Heather just said, though, it's just the start. We're just scratching the surface.
Yeah, and I mean, not to mention, sure many of your viewers know, but the United States has the highest incarceration rate in the world, and it's 300% higher today than it was back in the 70s when Gideon v. Wainwright first came down from the US Supreme Court and created an indigent defender system. What we have is an abomination on our record, frankly, as a country. So I'm not just talking about, you know, Western countries or countries with similar systems to ours. I'm saying we have the highest incarceration rate in the world. And the vast majority of the people incarcerated are poor people and people of color. Talk about a human rights abuse. Talk about a civil rights crisis in this country. And so programs like this give us one way to start to chisel away at that stone, but we need massive more grassroots movements of people saying enough is enough. If we took the money that we spend on a person who's in jail or prison and we applied that to healing some of the ills in their life, they would not come back and we would have fixed the problem. Instead, we have these ER-like court systems where people come in hemorrhaging, we throw on some punitive Band-Aid, send them on their way, and they come out 10 times worse than when they started, with their mental illnesses back at ground zero, feeling that they have no other options besides committing crime, because who's going to hire a felon? And frankly, taking drugs because life isn't worth living anymore. We have to give people opportunity, we have to address the root problems, and we can't have a system that is just punitive. It doesn't make any sense.
So you mentioned I'm all with you on addressing the core issues. And you mentioned that a high percentage of your cases tend to have mental illness as at least part of the issue. I've often heard it said that you don't go into the jail and find people who had a happy home life growing up. So what I would suspect that most of your clients have had a pretty hard life, poverty, those kind of issues. And of course, then they can't make bail because they don't have any money. They still don't have any money. So one of the things that's important to me, of course, is addressing the family issues at a much younger age so we don't have people who end up in this situation. And that's another program because that's not about the legal system. So I'll leave it there.
But you don't.
You'd have to get some people who work in the juvenile department here, neither of us do.
And I did work in juvenile for a year, and I think that dovetails nicely with another problem that I think of when I think about human rights and criminal justice, which I see a lot of in this county, is direct filing juvenile cases in the adult system. And so we have young people who are 15, 16 years old being treated as adults and sent to adult prison, when, just as you say, what we need to do with children, whatever it is that they're accused of doing, is find a way to rehabilitate them. And what we need to do at a grassroots level in our communities is find a way to address the roots of these problems so that we're not creating adult offenders, which I fear is what we're doing now. And the juvenile justice system in this county, I think, does a much better job than most of helping to heal families and helping to figure out the root of the problem and fix it. But if we have a DA's office that files these children as adults and treats them as adults and sends them to prison for the rest of their life as adults, our juvenile courts can't help them. So it's a big issue.
And that's being addressed somewhat. There is a county juvenile justice commission that met and presented its findings to the county board of supervisors 2 weeks ago. I was present. I spoke at that. The recommendations are good. There are some checks and balances other counties have in place historically that have been in place, which this county has decided to forego. They're still in the books. They can be used, and the recommendations of that commission were to re-implement those. I urge anybody who's interested to go look them up. They're a county-based commission. Their information's available through the Board of Supervisors website.
Yeah, these are our kids. This is our future. We need to invest in them as children and not just treat them as adults and warehouse them.
I know. I was surprised reading about a recent high-profile case that there are some major crimes that a youth will instantly be charged as an adult. No one has a choice. The DA doesn't even have a choice. Have I got that right, or did I misunderstand that law?
That's true. It's a very small number.
Is it?
That's in the 600 section of the Welfare and Institutions Code. There are some very small number of crimes that the district attorney is required to, if they're over the age of 15, are required to do what's called a direct file. However, there are quite a few crimes that are filed in this county that are not on that schedule. It's a very small list. I want to be clear, there are too many in this county. I completely agree with Heather. The numbers are not huge, though. I think there have been 5 this year. Jeff Roselle, the district attorney, did testify at that Board of Supervisors hearing. And the Board of Supervisors did request all the data on that information be provided to the Juvenile Justice Commission so they could do a full analysis of that. And I think they're scheduled next in March to have that on the calendar to discuss more.
Okay, great. Are there any other specific issues regarding the abuses of the system that you would like to address at this point? Because I know you mentioned some.
I want to say something about Santa Cruz County.
Okay.
We're talking, and we may launch now into a discussion about larger issues that face the criminal justice system and human rights abuses that occur there. Santa Cruz County actually, I wouldn't go so far as to call it a model, but it is not one of the most egregious abusers of this system. There are some programs in Santa Cruz County which are fantastic. There's a mental health services team known as the MOST team, which is part of probation, which is a state model. Also received state awards at the same Board of Supervisors meeting I was at 2 weeks ago. It is a model. I have personal knowledge that other counties come down here and model their programs based upon what they're doing. They're underfunded, there are not enough people on it, but their idea is to create wraparound services. So there are some programs doing this. There are some people who are trying very hard. I'm not just going to limit it to the probation department. There are people in law enforcement who are trying to work on this. There are people in the district attorney's office who are really trying to address this. But it's too few and they're not funded enough. And we need to figure out ways to empower them to actually be successful and to scale these models up. Because when they're successful, we need to figure out a way that more people get those services. I know Heather agrees with me. I make an argument to a judge almost every week that my goal is that this is the last time we see my client in court. And the only way that's going to happen is if we can get services for them. And Judge, you're the person who can allocate those services. So make it happen.
Yeah, it really is a funding problem. And I have to agree, having worked a lot of different places, that I've been by and large impressed with the system that we have in Santa Cruz compared to other places. But you have to ask yourself, compared to what? And again, it's not a finger pointing at our DA's office or our law enforcement or our probation department, because they're dealing with the resources they've been allocated. And until the people of our community and the people of this state decide that this is an issue worth paying for, we're going to have recidivism and we're going to have the injustices that we're talking about. It does come down to a certain extent money. Our community has a lot of impassioned people who want to do the right thing. Has to get paid for.
All right.
Now that we've absolved Santa Cruz County of most of these crimes, let's talk about things that are happening in other counties, because there are some big things.
Yes.
Here's one that is a particular problem for me. There are several firms in the state of California that are doing what are called lowest bid contracts for counties like ours. We talked about the 3 models of indigent defense in the state of California.
Right.
Those counties that have private firms that have contracts, like Bigham Christensen and Minsloff does with the county of Santa Cruz, there are firms coming in trying to underbid them. And that is a problem, because you cannot pay people the kind of salaries they're talking about paying people if you want people to stick around and give good indigent service. You just can't do it. And the numbers that they're talking about are ridiculous for people who have gone to law school, who have studied, who need to navigate this complex system. That's a big issue. And we talk about funding, we talk about services being provided. That doesn't work. I had a quote from Janet Reno about that. Janet Reno, the former Attorney General of the United States, said, "The lack of competent, vigorous legal representation for indigent defendants calls into question the legitimacy of criminal convictions and the integrity of the criminal justice system as a whole." You want the criminal justice system to work? You want to feel like it's working? This is the Attorney General, the lead prosecutor for the state, for the entire country, said this. The person who's the top of the food chain in terms of people who are trying to put people into jail.
Right.
She's saying, or said, when she was Attorney General, if you're not getting vigorous, competent defense, if you are not providing people, and I'm talking about indigent defendants, with good legal representation, if not great legal representation, then the system doesn't work.
Right.
The system is failing, and it is failing. Not so much in Santa Cruz County. We'd like to see more funding. We'd like to see more services. We'd like to create a system that made sure that our clients never came back, that our recidivism rate was 0. I can tell you right now, our recidivism rate in Santa Cruz is lower than 73%. That's the
Great.
state average.
That's good. And let's talk a little bit about the nation. I mean, I've seen some numbers that suggest that there are places, specifically mentioned was Florida, where people end up having to effectively pay for the right to a public defender. There's like a $50 or $100 fee to enter, application fee to get a public defender. Fortunately, I don't think we have anything like that in California.
No, we do.
Oh, we do? Oh.
It's actually a very similar system to Florida's, unfortunately.
Oh.
It's a fee that can be waived by the judges, and the judges all handle it differently. But there is a upfront fee when you apply for a public defender. It's a problem, in my view, because $50 is a lot to my clients, or at least to a large percentage of my clients. And I would hope that that $50 doesn't make them say, I'll just sit here in shackles and plead to whatever to get out and not consult with Ms. Rogers or Mr. Briscoe. I think in felonies we don't have that problem so much, but in our misdemeanor departments we very well may, where the fee for entrance is too much. You're charged with something like vagrancy or shoplifting or petty theft, and you think to yourself, yeah, maybe there's a Fourth Amendment issue, maybe I shouldn't have been stopped, maybe there's no evidence, but this judge is telling me that to talk to that public defender over there I have to pay $50. I don't have $50. She's also telling me if I just plead guilty, I'm out today. So it's a problem.
To be clear, we don't see that $50.
Oh, I'm sure you don't.
That would be real nice if we did. It's a bigger issue too, because let's talk about the bigger issue. Let's say you have mental health, severe mental health problems, and someone says, okay, you have to pay $50 to the public defender. Don't forget, you're getting out today. And they hand you a sheet of paper. I have clients who can't read, first of all. Second of all, I got clients with mental health issues who can't manage their own schedules. What makes you think they're not ever going to pay that $50? And I'll talk about other fines and fees in 1 second. But what happens if you don't pay that $50? You get reported to collections.
Almost immediately.
Almost immediate. I think it's within 2 weeks of failure
It's
to pay.
days within, yeah.
You get reported to collections. What happens at collections? Your credit gets ruined. Think you ever have a chance getting forward? I mean, I'm an attorney and my credit's not that good, right? I can't refinance a house. Imagine if you're an indigent client whose credit is ruined. I mean, it's going to take you 7 years, at least, to clean that up. That's the first piece of it. The second piece of this, and this goes back to the debtor's prison discussion, is about fines and fees which get tagged on to a lot of these petty crimes. So the minimum, I believe the current minimum fine you can get in Santa Cruz County for a misdemeanor is $320. I think that is...
That's the minimum.
Minimum.
Wow.
Again, courts can waive it.
Right.
Courts can apply custody time at $70 a day. That's apparently what you're worth, $70 a day off your fine. So as long as you're in custody 5 days, your $320 fine gets absolved. A judge
some
can
judges.
By some judges, not by all. So you get out of custody, you're poor, first you're indigent to begin with. Second of all, they charge you $50 just to get our help. Third of all, let's say you're in custody and we get a good resolution or get the case dismissed. Let's say we get you a good resolution within a week. You now have a minimum of $320 fine plus the $50. And the fact of the matter is you weren't making all that much money in the first place, otherwise you wouldn't have needed us. So you create these systems where we're basically adding these huge fines onto people who have no ability to pay them, knowing they have no ability to pay them, and creating, again, a series of debtors' prisons. Now technically, you're not allowed to jail somebody for failure to pay without a hearing to determine whether or not they have the ability to pay. But we do it anyway. It's a violation of the terms of their agreement. You go on probation, you agree to obey all laws and to make these fine payments. You don't pay them, what happens? Arrested, brought back into court. Why didn't you make the $50 more? Public defender's reappointed, second $50 fee. You may get tacked on another fine. There's a fine that's held over your head in all cases, felonies or misdemeanors, which is basically there to keep you from violating the terms of your probation. And if you violate them, they impose that, $200 more. And these fines add up. You know, I read an article about Florida, it may have been the same article you were reading, about a guy who got arrested for something, public drunkenness, and ended up with $1,400 in fines. And back in custody because he couldn't pay them. Right.
And it becomes debtor's prison.
Exactly.
Yeah,
And
and
as
we
you-
have that here. We absolutely happens every day in our courtrooms.
Well, as you mentioned, they go into jail, they potentially lose their job. So they could even, just the fact they got picked up, maybe they were completely innocent, but they might lose their job and then they have no way to pay that money back at all.
And their housing.
And their
And for
housing.
many of my clients, their car, because they got picked up on something after being pulled over. The car gets impounded. For a lot of my clients, the car is the housing. The car is the way to work. The car gets impounded. Every day you're sitting there with the judge not releasing you, there's impound fees being added to all of these other fines and fees that we just talked about. And it becomes completely overwhelming. And then God forbid you get sent to collections. I mean, I recently tried to pay a parking ticket that I got in front of the courthouse. It was late by the time it hit the system. Then they charge you a late fee. Then it goes to collections, they charge you a collections fee. I'm an attorney. gave up and took out my credit card. What about my clients who can't possibly navigate this bureaucracy? I mean, God forbid, they probably got a parking ticket too this morning at court, right? If you're there for more than 2 hours, you get the parking ticket too, which you can't pay because it doesn't hit the system until it's already late, and by then you have more fees and fines to pay on top of everything else, and they hold your driver's license until you pay them.
And so you can't legally drive either.
Which leads to another misdemeanor conviction.
Right.
And another $50 and the fines and the fees.
Yeah, driving without, I think it's $680, being caught without your driver's license. Even if you're legally licensed to drive, not having your driver's license on you.
Wow.
I think it's $680 right now.
There's sometimes I'm glad they didn't pull me over. That would have been expensive. Well, this is really great, and I would like to transition into personal stories, but I'm going to ask our director if she would roll a video right now that shows a personal story of one public defender in the South.
I always knew I wanted to be a public defender before I knew what a public defender was. I used to always get harassed by the police, and I said, I want to be somebody that prevents people from doing this. I love my job, I love my work, I love my clients, but there are things that I hate. I hate how this country treats poor people. I hate how individuals treat poor people. And so that's my hate that keeps me fighting. And I just like to fight. Like, I've always been a fighter. It just so happens this is the fight I'm in. When they say the state of Georgia versus Joe Blow, I look at it like, you got to get through me to get to Joe Blow. The state repeatedly in their opening statement found it important to tell you that this is not a serious case. But it had serious consequences. Serious consequences for that young man. They might call us liberals or progressives or whatever. But what I call us is true believers. And I call a true believer somebody who is really down for this PD work. They chose to be here. I feel severely the amount of time and the people's freedoms that is on my shoulders every day. And so I work 7 days a week, but just knowing that, you know, in a given case, if I don't do all I need to do, somebody's gonna go to prison. I think about that every case.
Mr. Cassidy,
when you take someone who's 25 years old and you give them 20 human beings and say these people's lives are in your hands, right? Go figure out how to save them. Boy, that can age you pretty quickly. What civil rights abuses that are happening today are happening to poor people and people of color in the criminal justice system. And they're happening because we can't afford to give them lawyers who can ensure that their rights, their civil rights, their human rights are protected in the criminal justice system. It's a system that sends a message to every public defender about the way they're supposed to practice. If you want to survive in this system, you can't fight judges every day to try to force them to do what's right. You have to get along to make this system work. What our public defenders are doing is they are saying, we're going to change the world one person at a time. Those lawyers are doing civil rights work. Most of them, their names will be forgotten, but their legacy is going to be a criminal justice system that we all know every person deserves.
Well, that's a really amazing story about a young attorney in the South. And I'm hoping to come back and see if you could just quickly tell me a personal story that either one of you might have that talks about how you've affected the lives of some of your clients.
Sure. 3 years ago, I got a client. Let's just call him John. That's not his name. And he was charged with raping a woman he had met at a bar. And he was incarcerated. No one would consider releasing him. John had no criminal record, no criminal background. He didn't present all that well. A mixed race kid, tattooed, early 20s. And I'd seen him around downtown prior, not as a homeless person. He had worked downtown in a variety of different places. And it became abundantly obvious within, I'd probably say 3 weeks of getting the case, that he didn't do it. That it was just really clear that he had not done it. And the district attorney's office came to that conclusion relatively quickly as well. And when I say relatively quickly, I meant my client spent 6 months in custody. And at the end of the 6 months, the district attorney's office agreed to release him, but did not agree to dismiss the case, and spent probably another 3 months trying to see if they could make a case. During that 3-month period, between the time he was released and the time that the district attorney's office ultimately dismissed the case, which was the correct thing to do, and I applaud them for that, no one would hire him, no one would talk to him, his friends wouldn't let him stay at their house. So he ended up basically my responsibility for those 3 months. John, I'll call him again, has never since been in any trouble. He has started his own business downtown. I'll give you his card later.
Okay.
He was what he was beforehand, a contributing member of society, and needed someone to believe in him. And I was able to do that for a short period of time. So.
Well, thank you very much. I have to wrap up the program now. I really appreciate your putting a human face on this tragedy of so many people not getting the services they need. And I'd like to thank you for watching. This has been Human Rights Here Now.
Some say the trouble's in the Pentagon. Some say the trouble's in the street. Some say the president's a paragon. Where's the trouble at the bottom? Some say the trouble's the anatomy. Some say the trouble's in the head. Some say the trouble's the psychology. Where's the trouble at the bottom? Trouble, trouble, where's the trouble? Oh mama, where's the trouble? Got a headache, seeing double. Where's the trouble at the bottom? Trouble, trouble, where's the trouble? Oh mama, where's the trouble? Got a headache, seeing double.